Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, and thank you for stopping by. Alright guys, what we're going to talk about on this episode is all about this new hearing of the assault weapons ban from California in the courtroom of Judge Roger Benitez. Now, a little bit of a backstory. Roger Benitez, or Judge Benitez, has already struck this down as unconstitutional. This is the whole thing that the California government and Gavin Newsom's hair was caught on fire when he compared the AR-15 to a Swiss Army knife, alluding to the common use. This is that same thing, only round two, with now ammunition from Bruen. But before we go into exactly where this is going, what the next steps are, and presume that Benitez is going to pass it along, which most likely is going to happen, I want to focus on the actual introduction of this round two, if you will, in Judge Roger Benitez's courtroom. This is a clinic on freedom. I'm about to walk you through this introduction in the actual verbiage submitted to the court. If you are in Maryland, if you're in Colorado, if you're in California, anywhere where there are assault weapons ban or unconstitutional moves made against the Second Amendment, this is a masterclass, and I can only say, chef's kiss, baby. Because the way that this is written, it is literally a flowchart of freedom. We cascade all the way for our gun rights, and that is what we're about on this channel. So, if you think we earned that subscription, we are always looking to get as many people in the fold as we can to get some positive 2A news out there as soon as we can, so you guys are informed we can make some positive moves for our rights. But enough of that. Everything is linked in the description box below per usual, and I want to hear from you guys on this one. So what we're looking at on screen right now is the actual document from the court. You've got James Miller, Rob Bonta, you got as a plaintiff, you got Benitez, all the players. But let's dive into this because there's a few points. The way that Bruen and Heller are interwoven in this introduction is ironclad. It is soundproof as you can get, and honestly, watertight. This is beautiful. But I want to show you because this is the power of our activism. Plaintiffs, James Miller, known as plaintiffs going forward, hereby submit this brief addressing New York State Rifle and Pistol Association Incorporated v. Bruen. Pursuant to this court's order of August 8, 2022, so this is round two in his courtroom, Bruen does not change the outcome of this case. Instead, Bruen vindicates this court's previous application of the Heller test and establishes that plaintiffs must prevail in their challenge to the state's Assault Weapons Control Act. That is the assault weapons ban of California. This thing goes away, it is the thread that pulls the sweater even further than Bruen, because then you got to go to Maryland, then you got to go to Colorado, then you got to go Washington State, Washington D.C., New York, Illinois, all the places, because they've interwoven their gun control so tightly. You start to pull these things away with court decisions, and they're kind of left bare. Anyway, let's keep going because the stuff in here is, as I said, delicious. In Bruen, the court reasserted principles it clearly applied in Heller. There can now be no dispute over the proper approach to evaluating Second Amendment claims. And a little note before I continue. I love the assertion in this language. This is very strong. This is very dominant language, and I love this. There can now be no dispute over the proper approach to evaluating the Second Amendment claims. First, the court must determine whether the Second Amendment's plain text covers an individual's conduct that is being restricted by a challenged law or policy. Second, if the answer is yes, the conduct is presumptively protected, and the burden then falls to the government to justify the challenged restriction by, quote, demonstrating that it is consistent with the nation's historical tradition of firearms regulation. There's that Bruen fold in. Like I said, this is going to cascade in a case for freedom like you've never seen. This is a flowchart of freedom, if you will. If the government cannot make this demonstration, the restriction is unconstitutional. Full stop. I love that. No interest balancing or levels of scrutiny analysis can or should be conducted. Now that, just so if you guys are not fully aware, the interest balancing is what courts on the left was doing across the nation, where they said, well, yes, you have your Second Amendment rights, and that's all well and good, but we have to take in consideration the balance of interest for the safety of the population and the public. New York's doing it, California's doing it. That's the whole sensitive places thing, all about protecting the interest of the population. Bruen clearly says you can't do that, which is why the fights are continuing. But here, that's the first interweaving of that. Now, let's keep going. First, Bruen confirms the Second Amendment's plain text covers the activity at issue, possession of a bearable arm. Reiterating what was said in Heller, Bruen states that, quote, the Second Amendment extends prima facie to all instruments that constitute bearable arms. Second, Bruen confirms that Heller already has conducted the relevant historical analysis for determining whether a particular arm falls within the Second Amendment's protection and therefore cannot be banned. In order for a ban of a type of arm to be consistent with the nation's history of firearm regulation, the government must demonstrate that the banned arm is dangerous and unusual. Dangerous, unusual, you're getting into the NFA territory. That's something that like a full auto would be deemed dangerous and unusual, not in common use. That's where they're going next, because common use is something that we've hit on multiple times like a hammer and an anvil on this channel, and we're going to continue to do it because that is where this is going. Check this out. It follows that types of arms that are in common use today simply cannot be banned. And the AR-15 is the most popular platform of firearm in the United States. It's as common as you can get. That's why Benitez in his first ruling said the Swiss Army knife, because he alluded to common use. And Bruen has only buttressed and supported the Heller decision. Let's keep going, because like I said, this just like sets a fire in your soul. This is so good. These principles decide this case. Once it is determined that the AWCA bans arms that are in common use, it follows that the law is unconstitutional. Period. God, I love that. And this court has already made the determination. In its prior opinion in the case, the court concluded that the banned arms are, quote, very popular hardware, firearms that are lawful under federal law and under the laws of most states and that are commonly held by law-abiding citizens for lawful purposes. Miller v. Bonta. Accordingly, all that is left for this court to do is reinstitute its decision finding California's ban unconstitutional under the legal principles confirmed by Bruen. What you just heard, what I just walked you through, was the way that the Bruen decision and the Heller decision are tied together in a tremendous wrecking ball of freedom that is going to destroy the unconstitutionality of all the gun bans, of all the mag bans, everything from Maryland, from Colorado to California, Washington State, Washington, D.C., New York to Illinois. The main thing that this has done is this gives you multiple tests, it gives you multiple precedents, and it gives you multiple cases to tie together. This introduction was a masterclass. The rest of the entire document goes forward and proves that even further. And that's what I've got for you guys. Let me know what you guys think in the comments field below, and I will see you tonight at the 9 p.m. segment. I'm Braden. See you later.